Even though inmates are sent to prison, they are still afforded First Amendment protections despite the fact that they are incarcerated. When referring to the freedom of religion, legal scholars should consider that religious freedom contains two parts. These are the Establishment Clause and the Free Exercise Clause. The Establishment Clause essentially suggests that the government must neither favor nor inhibit religion. In corrections law, very few cases are filed under the Establishment Clause. Having said this, with the recent introduction of faith-based initiatives in correctional facilities, new challenges to the Establishment Clause have arisen. Litigation in this area will focus on whether or not faith-based programs violate the First Amendment Establishment Clause. Whenever courts are examining whether or not the Establishment Clause of the First Amendment has been violated, they should ask whether or not a correctional agency has a policy that either advances or inhibits religion. If the answer is yes, then it is likely that a court will rule in favor of the inmate plaintiff. As this presentation will show, the vast majority of prison religion cases arise under the Free Exercise Clause, where an inmate plaintiff alleges that a correctional policy in some way prohibits his or her religious practices. One of the earliest U.S. Supreme Court cases examining prison religion issues was Cruz versus Beto, where a Buddhist inmate residing within the Texas prison system maintained that he was not permitted to use the prison chapel or share his religious materials with other inmates. In fact, this inmate was even punished and placed in solitary confinement after attempting to pass out his religious material. Although the federal district and appellate court dismissed the prisoner's complaints, ultimately the U.S. Supreme Court decided that both of these lower courts were too hasty in dismissing the complaints. Though the court did not offer a fully developed opinion, it provided an equal protection analysis and essentially posited that if a correctional administrator allows accommodations to one religious group, he or she must make similar accommodations to another religious group. It was not until 1987 when the U.S. Supreme Court would make another significant ruling regarding religious activities in prison. In Olone versus Chavez, the court ruled in favor of correctional administrators and held that so long as prison administrators act reasonably and with good cause, they can take measures to limit a prisoner's religious freedom. This is consistent with the ruling in Turner v. Safley, which was also handed down in 1987. Here, the court ruled that a regulation is valid if it is reasonably related to a legitimate peniological interest. What is interesting, though, is that Congress objected to key aspects of the Olone case and enacted the Religious Freedom Restoration Act in 1993 in an attempt to remedy this. Legal scholars have suggested that the Religious Freedom Restoration Act was an attempt by Congress to overturn the Olone ruling. In fact, this federal law raised a very serious question about the separation of powers of government. Interestingly, 4 years later, the U.S. Supreme Court would rule that the U.S. Congress had exceeded its power and that the Religious Freedom Restoration Act could only apply to inmates in federal prisons, but not inmates in state prisons. So, in essence, the court overturned a federal law and held that it was unconstitutional. The majority opinion specifically stated that Congress's discretion is not unlimited, and that ultimately courts retain the power to determine if Congress has exceeded its authority under the Constitution. The U.S. Congress was so committed to giving inmates religious freedom that it passed the Religious Land Use and Institutionalized Persons Act of 2000. It is worth noting that this piece of legislation was passed only 3 years after the court had overturned several aspects of the Religious Freedom Restoration Act. Apparently, congressmen and women on both sides of the aisle were committed to maximizing the religious freedom for incarcerated persons. This act essentially declared that if a correctional agency attempts to limit a prisoner's religious freedom, there must be a compelling governmental interest. And additionally, the act declares that if a correctional agency must limit religious freedom, it must use the least restrictive means. The U.S. Congress rarely attempts to pass new legislation to circumvent a ruling by the High Court. The court could have easily shot this law down as it previously did. However, in 2005, 5 years after the act was passed, the U.S. Supreme Court affirmed the Religious Land Use and Institutionalized Persons Act of 2000 in a unanimous Supreme Court decision. There is no question that the Religious Land Use and Institutionalized Persons Act will continue to generate litigation about how correctional agencies must accommodate the religious rights of prisoners. Recent cases involving the free exercise of religion among inmates have involved the issue of special religious diets and grooming. Generally speaking, in recent cases, courts have sided in favor of correctional agencies in matters involving special religious diets, especially when it can be shown that implementation of such a diet program would be a significant financial burden. The courts, however, have been mixed as to whether or not inmates can avoid strict grooming standards due to religious reasons. As of today, the U.S. Supreme Court has not ruled on either issue. Now, let us turn to the issue of inmate discipline. Almost anyone who has worked in a correctional facility realizes that it is absolutely necessary to have a disciplinary process that punishes inmates for infractions of the rules. After all, without discipline, it would be impossible for correctional administrators to have facilities which are orderly and secure. Nevertheless, in spite of the importance of inmate discipline, the U.S. Supreme Court has ruled that inmates are entitled to due process protections in serious inmate disciplinary cases that involve serious liberty interests. For example, if an inmate stands to lose good time credits, this generally is sufficient to trigger due process standards. Wolf versus McDonnell is considered to be the granddaddy of inmate discipline decisions. In this case, the U.S. Supreme Court ruled that an inmate is accused of committing a very serious disciplinary infraction, especially if this is an infraction that might result in significant punishment, such as the loss of good time credit. So if the inmate's accused of this, then he or she is entitled to advance written notice of the claimed violation. The court in this case prescribed that the accused inmate should have at least 24 hours notice. Also, the court in the Wolf case maintained that an inmate who is accused of a significant disciplinary infraction should be entitled in some cases to call witnesses or at least present evidence on his or her behalf. And if a prisoner is illiterate or the disciplinary case is quite complex, the court suggested that inmates should be free to have adequate aid from either a correctional staff member or a sufficiently competent prisoner. While there is no question that Wolf versus McDonnell was a victory for inmate rights advocates, the court still recognized that prison officials should have the discretion to impose reasonable limits on the disciplinary hearing. If, for example, an inmate wants to call a witness and it is deemed by correctional officials this might create a risk of reprisal or in some way undermine the agency's authority, the prison administration does not have to allow this. Also, inmates do not have a right to confront and cross-examine adverse witnesses during a disciplinary hearing. And while inmates may be afforded a staff member during a disciplinary hearing, they are not entitled to an attorney. Also, prison administrators may use evidence collected by confidential inmate informants. And while the U.S. Supreme Court has not ruled on this issue, lower courts have held that it is permissible for confidential inmate informants to provide information which can be used as evidence at another prisoner's disciplinary hearing. And in order to protect the informant against reprisals, correctional officials do not have to reveal the identity of the informant so long as they are satisfied of the reliability of the information. It is also important to point out that double jeopardy does not apply to prison disciplinary cases. For example, let us suppose that a prisoner participates in a riot. Even if the inmate is punished by a prison disciplinary committee, which is administrative in nature, he or she can still be subject to criminal prosecution. This does not constitute double jeopardy, since double jeopardy only applies to criminal punishments for the same offense. Also, it is worth noting that the standard of evidence necessary to find an inmate culpable of violating a prison rule is much lower than it would be in a criminal court. According to the Superintendent versus Hill ruling of 1985, only some evidence is required to support the findings made in disciplinary hearings. Obviously, this standard is much lower than the beyond a reasonable doubt standard in criminal courts, as well as the preponderance of the evidence standard in civil courts. Again, it only needs to be shown that there is some evidence and that a prisoner can be found culpable of violating a significant regulation which might result in the loss of good time or even offset his or her parole hearing. What happens if an inmate decides to remain silent during his or her disciplinary hearing? Can this adversely affect the outcome of the hearing? The answer is yes. While there must be additional evidence to support the charges, officials may draw adverse inferences from an inmate who chooses not to answer questions during the disciplinary proceeding. However, if an inmate is compelled to answer questions during a disciplinary proceeding, the answers to these questions cannot later be used in a subsequent criminal proceeding. So, for example, if an inmate assaults another inmate and then admits to this in a disciplinary hearing, he would have to be given immunity for this statement if officials wanted to press charges in a criminal court. Despite the fact that incarcerated persons have diminished constitutional liberties, as this presentation has illustrated, there are limits as to how much the state can impose its will on those who reside within correctional facilities. By way of conclusion, inmates do have First Amendment protections in regard to the free exercise of religion, as well as Fifth and 14th Amendment due process guarantees during disciplinary hearings, which may result in a significant deprivation, such as the loss of good time. Given this, it would behoove correctional administrators to familiarize themselves with the legal rights of the inmates they are paid to supervise, as this will limit civil liability and perhaps even go a long way toward the rehabilitation of the inmate population.